smuggling and border security. And of course, we also work with the Ministry of Human Resources and in coordination with other UN agencies on migrant protection and labor migration, which is what we are here to mostly talk to you about today. So being a major destination for migrants all around Southeast Asia, Malaysia is becoming increasingly vulnerable to human rights violations, and companies are at risk of being banned from selling to countries like the US and soon Canada and elsewhere unless practices are improved to reduce forced labor. Next slide, please. There are currently more people moving now than any time in recorded history. In a global population of 7 billion, 1 billion are migrants, with 48% of the global migrant population being women. So there are 250 million who are international migrants, 760 million are internal migrants, and 150 million are labor migrants and their families. So interestingly enough, 30% of all international migrants are born in Asia Pacific and 16% live in the region. So global migration has led to USD 600 billion per year in remittances. Next slide, please. So if you look at the screen, you can see key figures related to forced labor, which was extracted from the Global Estimates of Modern Slavery. So the Global Estimates is an open access resource that has resulted from the collaborative efforts between ILO, the International Labour Organization, Walk Free Foundation, and IOM, with inputs from other UN agencies as well. So it includes global data on forced labor, debt bondage, forced marriage, other slavery and slavery-like practices, as well as human trafficking. So if you look at the screen, you can see that there are over 40 million victims of human trafficking and slavery around the world. Of this 40 million, I think you need to click some more so that, yeah. Of this 40 million, 25 million people are in situations of forced labor, with over 16 million in the private sector. So notably, of the 16 million, over half are affected by debt bondage, with approximately 70% for agriculture, domestic work, and manufacturing. So this is an area which I will be spending some time on in the later slides. For forced labor, the prevalence is highest in Asia and the Pacific, with 62% of victims of forced labor being in the Asia Pacific region. Sorry, give me a second. Yes. So if you look at the slide now, you can see that well-managed migration benefits all. Migration is a reality that needs to be considered when we talk about addressing forced labor. We at IOM believe that well-managed migration will benefit all. So for workers, it provides an opportunity to raise income levels, gain skills, and improve living conditions for families and communities. In countries of destination like Malaysia, as we're all aware, labor migration helps address critical labor shortages. And here in Malaysia, migrant workers represent an estimated 15% of the Malaysia workforce. But I would like us to focus for a moment on the countries of origin perspective. So countries of origin and their communities are usually the ones most severely affected by forced labor and unethical recruitment practices. Also, when it comes to international recruitment, most of the heavy lifting happens in the origin countries. This is often not visible for countries of destination like us and multinational businesses and their supply chains. Countries of origin invest a lot of time and resources to set infrastructures for outbound labor migration and international recruitment. So while doing so, they also need to face questions about sensitive issues such as brain drain and brain waste. Yet, if well organized for countries of origin, labor migration reduces the stress of national unemployment or underemployment and contributes to development through remittances, transfer of skills, and the creation of business and trade networks. Next slide, please. So here you can see what is a simplified labor migration process. The journey that migrant workers take to work overseas can be broken down into 4 key parts. The first being recruitment, followed by deployment when they leave their country, employment here in Malaysia, and lastly, return or onward migration. While migrant workers can be vulnerable to exploitation during each of these phases, for now, we want to focus specifically on the recruitment stage. Next slide, please. So let's just spend some time here on understanding why migrant workers are more vulnerable. So the first, of course, there are language and cultural barriers. Migrant workers who come to Malaysia, especially if it's their first time working abroad, are likely not able to speak the local language, which then becomes a significant challenge. Secondly, they are also leaving their families and support networks behind, which may lead to isolation and difficulty in obtaining support if they need it. Thirdly, there is discrimination and social isolation in Malaysia in particular, where xenophobia has been on the rise since the pandemic. Migrants also suffer from this. Next, often migrant workers are not aware of their legal rights and protections. And the simple question is, if a migrant worker is not aware of what his rights are, then how can he assert those rights? The next one is employer-specific work permit. So this is quite a unique issue to Malaysia, because in Malaysia, migrant workers, they hold employer-specific work permits. What this means is that a worker cannot change employers even where he has been exploited. So if he leaves his employer, he then becomes undocumented when the employer reports that he has left. This puts the migrant workers in an extremely vulnerable situation. And while there are legal avenues to change employers, usually the workers need the approval of the earlier employment, and this consent will not be given. So there are also other exceptions, but these are very, very rare. And connected to that, of course, is that because of the risk of migrant workers becoming undocumented, migrant workers are also afraid of being deported, hence forcing them to remain with employers, even where they suffer conditions of forced labor. The next one is the lack of access to justice. So there is a lack of access to justice for migrant workers, especially once they have returned to their countries of origin. While Malaysian employment law is by and large equal for citizens and non-citizens, the reality is migrant workers cannot afford legal representation, nor are they able to remain in the country to pursue court cases where they have left their employers. There is a special permit for workers to pursue court cases, but these special permits, I think, are renewable every either 1 or 3 months, and they are very expensive. So if a migrant worker is unemployed because he's left an employer, how is he going to afford those special work permits? And lastly, of course, migration costs. So migration costs are high for migrant workers, where a lot of migrant workers pay excessive fees and costs, leading to debt bondage. When a migrant worker, for example, owes 2 years worth of wages as recruitment fees, he is unlikely to leave his job even when he is being exploited. Next slide. So the current recruitment model is geared more towards the employer rather than the worker. In many cases, the recruitment agencies recoup their money from the worker rather than the employment, or sometimes they even take it from both sides. So migrant workers are already vulnerable and have very little bargaining power in terms of what and how much they pay. Furthermore, if there are several agencies and brokers involved in the recruitment process, this can create even further fees and costs for the workers. In many cases, workers don't have the money upfront to cover this cost and are forced to take out loans, often with high interest rates, to cover the migration costs. So from our own research at IOM, we found examples where workers are paying up to almost 2 years' salary for their jobs here in Malaysia. This put migrant workers in an extremely vulnerable situation. Next slide, please. So here we are going to cover what can go wrong for workers. Sometimes when workers are forced to pay for their jobs, which is unfortunately very, very common for our workers who come to Malaysia, their passports are taken away as collateral to stop them from leaving until their debt is paid off. So, and also similarly, sometimes workers are misled about the job on offer. So, for example, a worker might believe that they are coming to Malaysia to work in a restaurant or a hotel, but they find out on arrival that they're actually working on a palm oil plantation and are required to perform hard manual labor. So this job might be unsuitable for them, but they cannot leave due to the debt that they have incurred in order to get that job. So when all or even just some of these factors combined, it creates a situation where workers are essentially trapped in their jobs and can be considered victims of modern slavery. It is also important to note here that all of this can occur even without the employer's knowledge, and this can put them at risk too, which emphasizes the importance of employers conducting due diligence with the partners they work with, whether it be recruiters or the management agencies they hire to manage the migrant workers. Next slide, please. All right, so before we go into the other common risk areas, when it comes to the recruitment and employment of migrant workers, I would just like to take the participants here through the findings from the 2021 Trafficking in Persons report. So in June of 2021, the US State Department released the 2021 Trafficking in Persons report, where unfortunately Malaysia was downgraded to Tier 3, having been on the Tier 2 watch list for 3 years already. So the last time that Malaysia was on Tier 3 was in 2014. So here on the screen, you can see the general findings that were made in the report on forced labor. What the report found was that the government pursued cases of forced labor as disparate labor law violations instead of criminal cases of human trafficking, or they failed to investigate at all. They did not adequately address or criminally pursue credible allegations of labor trafficking in the rubber manufacturing and palm oil sectors that were made by the international media, NGOs, and foreign governments. They did not initiate investigations of 2 Malaysian companies in the palm oil sector for forced labor allegations that occurred during the reporting period. The Malaysian government also did not report if it investigated a formal complaint filed in August 2019 detailing allegations of forced labor at a Malaysian palm oil company's plantation, which was partially owned by the government. They also did not report investigating or prosecuting as trafficking crimes allegations from 2018 that several rubber product manufacturers exploited migrant workers, including through methods indicative of forced labor. So if you go through the report, these are all findings you'll find in the report. If we could move on to the next slide, this will cover the more specific findings that were made by the US state government. So firstly, on living conditions, the Labour Department initiated 57 investigations against employers in the rubber product manufacturing sector to confirm compliance with housing laws. In December of 2020, the government filed 19 charges against a disposable glove manufacturing company under the Workers' Minimum Standards of Housing and Amenities Act for inhumane living conditions in migrant workers' dormitories. And the government also filed 30 charges against another rubber glove manufacturer following a series of raids where the labor inspectors discovered more than 200 foreign workers living in inhumane and unsanitary conditions. Then they also went on to talk about debt-based coercion. They reported that Malaysian government did not report investigating or prosecuting these companies for human trafficking crimes, despite credible evidence of debt-based coercion. So it's interesting here because you will note that now debt-based coercion is an element of human trafficking. Next slide, please. Labor inspectors. So the Malaysian government reported that they have 94 labor inspectors for the entire country, which is a very, very small number. 65 assigned to Sabah, where there are a large number of Malaysia's palm oil plantations. 24 assigned to Peninsular Malaysia. So there's only 24 labor inspectors for the entire Peninsular Malaysia, and with another 5 assigned to Sarawak. So the lack of adequate resources, including for additional labor inspectors, hindered the government's efforts to adequately identify labor trafficking and enforce the prohibition on employer-perpetrated passport retention, which remains widespread. This is also consistent with the research and the assessments that have been done by IOM. So for withholding of passports, the government reported that they convicted 26 individuals for withholding the passports of employees under the Passports Act of 1966. So we'll be covering this a bit later as well. But just to explain why 26 individuals were convicted, it's because the company is not the one that's brought to court. The director of the company is the one that's brought to court for this offense, hence individuals. So lastly here are the labor courts. Malaysia reported that our labor courts resolved 10,465 labor disputes and ordered employers to provide workers back wages amounting to 18.06 million ringgit and levied fines against employers who violated labor laws of almost 500,000 ringgit as well. So the next slide, please, which is the final slide on the TIP report. This just covers the other miscellaneous findings in the report. So civil society observed that a lack of adequate efforts to inform migrant workers of their rights and Malaysia labor regulations. So this was something that we covered earlier as well. If migrant workers don't know what their rights are, then they can't assert those rights. So they also found that employers utilize practices indicative of forced labor, such as restrictions on movement, violating contracts, wage fraud, assault, threats of deportation, the imposition of significant debts, passport retention, which remains widespread, to exploit migrant workers in labor trafficking. So the sectors which were emphasized here were oil palm and agricultural plantations, construction sites, electronics, garment, rubber product industries, and of course, domestic workers who work in private homes. And they also made a mention of a 2018 NGO report which documented multiple indicators of forced labor associated with the production of palm oil in Malaysia, including coercive practices such as threats, violence, lack of clarity of employment terms and conditions, dependency on the employer, lack of protection by police, debt bondage, high recruitment fees, and involuntary or forced excessive overtime. So if we could move on to the next slide, here what I will do is we will now look at the common risk areas during the recruitment, employment, as well as those which are related to living conditions. And we will also cover specific risks which are prevalent in the palm oil industry. So if we move on to the next slide, the common risk areas during recruitment. So the most common risk areas, and one that we have found in every risk assessment we've conducted in Malaysia, is excessive recruitment fees and costs. So the costs which are paid by the migrant workers who we have interviewed range from thousands of ringgit to tens of thousands of ringgit, usually quite similar between migrant workers of the same nationality. So for example, the highest that we have seen goes up to over 20,000 ringgit. And this is usually the amounts which are paid by migrant workers from Bangladesh. It is also important, I think, to remember here that these are huge amounts paid by migrant workers to obtain what is usually a minimum wage job. So if a migrant worker from Bangladesh pays 20,000 ringgit and comes here and only earns 1,002 or 1,001, even if there is no interest, which is unlikely, he will take over 20 months or almost 2 years to repay that sum, putting him in debt bondage. So earlier, we already talked about deceptive terms and conditions, where a worker may be promised a very different job, or maybe they're promised a much higher wage than what he actually gets once he or she arrives in Malaysia. So that is also a huge problem. So in our assessment, we have also found that there are recruiters or sub-agents in the countries of origins who withhold the personal documents of migrant workers for months on end. So this is not just passports. So they retain passports, they may retain training documents, education documents. We have also seen cases where they hold the marriage certificates of the workers. So they actually hold these documents for a prolonged period, even when there is no job offer. And the reason why this is done is so that when a job order does come through, they are able to fulfill this job order immediately. So that's why they want to hold everything. So what this actually means for the migrant worker is that even though there is no job yet, the migrant worker remains unemployed, and yet he is unable to look for another job because his documents have been taken away. So this again puts the migrant worker at risk. So if we move on to the next slide, we will talk a little bit about
Sorry, Joanne.
Yes.
I wonder whether there's quite a number of questions in the chat. Do you want to take them throughout or at the end?
Well, if they're relevant now, I guess I can take them now.
Okay, I mean,
could you moderate the chat box?
Sure.
Oh,
okay, perhaps move just a few, in fact, quite a few questions about IOM. What does it mean that Malaysia is an observer status?
Good question. So basically, Malaysia is currently an observer. They are not a member state because a member state would have voting rights, but also they have to pay membership fees. So Malaysia is not there yet. So currently they are an observer state. So they only observe, they do not vote yet. So perhaps I hope that answers the question.
Second question, how does IOM differ from UNHCR?
Oh, okay, sure. So UNHCR is the UN Refugee Agency, and IOM is the UN Migration Agency. So our mandate is quite different. IOM's mandate is wider. We look at the whole of migration. So it would include refugees, it would include migrant workers, it includes asylum seekers, where else UNHCR only looks at refugees. So perhaps I can just speak a little bit from the Malaysian context. Even in Malaysia, we do different work. So for example, in Malaysia, UNHCR, they handle the registration of refugees. But when it comes to the resettlement of refugees, meaning the movement of refugees from Malaysia to their third country, then IOM manages that. So we do not, so our work does not overlap, but then we work together and the work is complementary.
Thanks. Next question, why does UN use the word migration or migrant worker instead of foreign workers or foreign labor? Is there a difference?
That's a good question. So for IOM, we have a migration glossary, and then that's what we use. I would say that we try to use words which are more appropriate and afford migrant workers the dignity that they deserve. So for example, they are people, they are not just labor. And something that we really don't like to see is in Malaysia, the commonly used word is parti, for example, right? Pendatang asing tanpa izin, or known as illegal immigrants. So I hope that if the participants here take away one thing, just stop using the word parti, stop using the word illegal immigrants, because if you're a human being, you can't be illegal. And even the word immigrant in itself, it's inaccurate. So an immigrant is someone who migrates long term, right? They want to move to Australia, they want to remain there forever. Well, the people who come to Malaysia are migrant workers. They're only here temporarily. They do not want to stay here. They want to work here and then they want to go back. So I think it's important that we use words that are accurate and that are not degrading to migrant workers who contribute so much to our country and to our economy. Carl, any more questions?
Yeah. Robert asked whether you can, and Ms. Joanne may enlighten on Malaysia entering other countries as migrant workers. Nothing specific here, but unless you want to handle that, or we can seek further clarification later.
Perhaps you can seek further clarification later if you have some time.
Yeah. Okay, let's do that at the end. And also, how did the government respond to the tip report?
That's a good question. So I think the government is doing a lot to respond to the tip report. So I think the government also recognizes the situation of forced labor here. In the past couple of days, you can see that the Minister of Human Resources has released quite a few statements about forced labor and, recognizing that it exists in Malaysia and that Malaysia will be fighting forced labor. And in fact, I'm not sure how many of you are aware, but the National Action Plan for Forced Labor was also launched by the minister last Friday. And interestingly enough, during his speech, the minister said that we had migrants coming to Malaysia 200 years ago, and back then when they worked on their estates, their condition was better than the condition of the migrant workers today. And he said this after having conducted labor inspections himself together with the labor inspectors.
Thanks, John. I think we handle the other questions later on.
Okay, sure, no problem. So if we could just come back to the slides where we will talk about the common risk areas during employment. So this list is not exhaustive. There are other risk areas as well, but then these are just the ones which we most commonly see that is quite widespread across sectors. So it's not specific to any sectors. Actually, most sectors have the same common risk, and we can go through some of them here. So the first one that we commonly see is unlawful wage deductions. And something that's quite surprising is that often the companies are not aware that they cannot simply deduct this they cannot simply deduct these wages. So the general rule is that there should be no deductions without the prior permission in writing of the Director General of Labour and the request of the migrant workers. So this is under the Employment Act. There are some exceptions. You can find them in the Act, but these exceptions are very, very few, and they usually do not apply to what the companies deduct the wages for. So if I could give an example of a case which I did when I was in legal practice, I represented a multinational company who had been taken to court for deducting 50 ringgit, just 50 ringgit, from migrant workers as a security deposit for the accommodation. So you cannot do this. They did not get the written permission of the Director General, and of course the migrant worker hadn't asked them to do it. So in their case, these deductions had actually been done by the agency managing the accommodation and the payroll without the knowledge of the employer. But of course, that is irrelevant to the court, because on the work permit, it's the employer's name. So what happened in the end was the company ended up paying compounds of 10,000 ringgit for every 50 ringgit that had been deducted. So I mean, that's a significant sum that they had to pay because 50 ringgit had been deducted. And then of course, they had to pay a significant sum for legal representation as well. So this again emphasizes the importance of employers conducting due diligence on the agencies that they engage when it comes to the employment of the migrant workers, and making sure that the agencies are operating legally and ethically. So secondly, here is salary calculations. So in our assessments, we have found that salary calculations are not detailed clearly in the salary slips, and deductions, lawful or otherwise, are also not specified. So this becomes a bigger risk when the salary calculations are not properly done in line with the Employment Act, and the migrant worker is actually paid lower than he should be. So when we compare, how many hours the migrant workers have worked, and then we compare what the salary is, we find that actually the salary has not been calculated properly, meaning he may have worked on his rest day and he was not paid accordingly. So salary slips should also be clear with proper calculations, and any lawful deduction has to be specified. This slips should also be explained to the migrant workers, and ideally in their language. So the third one here, which is also very common, is forced excessive overtime. So this is something that we have seen in our assessments and has been reported in the media quite widely as well as something that's widespread in Malaysia. In some extreme cases, with workers reporting being forced to work 7 days without rest, up to 12 to 15 hours a day. So this is, of course, not great for health and also could lead to workplace accidents, which we also know has been reported in the media in certain industries. So as it stands, the law only allows for 104 hours of overtime a month, and this must be voluntary. There are only very specific instances where employers can require workers to work overtime. This is also in the Employment Act. So the fourth one here is the freedom of association. In our assessments, we have found that often workers are not aware that they can join unions. We have also seen multiple companies who have employment contracts which specifically forbid migrant workers from joining unions. This is unlawful. Our law clearly states that migrant workers are entitled to join unions. They are not legally allowed to form unions or to hold office in unions, but they must be allowed to join unions if they want to. The fourth one here, unfortunately, cases of physical and mental abuse are also not unheard of in Malaysia. We have seen this in our assessments, and they are also reported in the news. Lastly, rest day, annual leave, sick leave. Migrant workers have also reported not being able to take these days off, despite these rights being provided for under the Employment Act. So these are all risk areas that are quite common among employment in Malaysia. If we could go to the next slide. So common risk areas related to living conditions. The first one is, of course, the lack of safe and hygienic living conditions. This in particular has been an issue that has been spotlighted during the COVID-19 pandemic, not just in Malaysia. We have seen it in Singapore. We have seen it in the other countries as well, which have a huge migrant worker intake. We have heard a lot about migrant worker clusters, especially in Malaysia. In 2020, it was reported that the largest cluster at that time was found to be from one single company with more than 5,000 workers being infected. And then in July of this year, the Construction Industry Development Board reported that 188 construction sites were ordered to close for breaching SOPs. And I think if I remember correctly, in the news, there was one specific site that was closed down twice. So, I mean, if you just ask yourself this simple question, why do migrant workers happen? Is it a breach of SOPs at the work site? Is it because PPEs are not provided properly? Or it could be the crowded, indecent, and unsanitary accommodations that migrant workers are provided with. So the minister himself, the Minister of Human Resources, in 2020 said that 90% of migrant worker accommodation is in breach of the Workers' Minimum Standards of Housing and Amenities Act 1990. I mean, this is very, very high. It's 90%. And the following year, he stated that 115 investigation papers had been referred to the Attorney General's chambers, with 70 already being given the green light to proceed to charges in court. So we're going to be seeing at least 70 different cases in court. So before I move on to the next topic, perhaps what is even more shocking than the fact that 90% of employers are in breach of the minimum standards is the minimum standards themselves. So if you actually go and look into the act, you will see that the minimum standards are very, very, very low. So for example, the law only requires that employers provide one bathroom and toilet for 15 workers. That's 1 to 15. And also the law only requires employers to provide a bedroom floor area of 3.6 square meters per worker if it's not a dorm, and 3 square meters if it's a dorm. So I mean, if you look at the standards, if you think about how 90% of companies are not even abiding by the standard, then are we really surprised that migrant workers end up contracting COVID-19 in clusters? So I think it has never been more important to be aware of the prevalence of migrant workers in supply chains and the treatment or mistreatment that they are receiving than it is now. And it's sad that a pandemic has to be, the thing that makes us realize that before we are spurred to take action. So the second one here is, we also talked about this just now, is the retention of personal documents. The retention of personal documents, especially passports, remain common in Malaysia. This is what we have seen in our assessments. This is what has been reported in the TIP report. In our assessments, when we interview the workers have their passport, but then they tell us, oh, actually, the employer gave us back the passport yesterday. So this happens not during recruitment. It happens during employment as well. And this is despite the fact that the Passports Act makes this unlawful, and directors could face imprisonment up to 5 years and a fine of up to 10,000 or both. So this is something that we know is being actively pursued by law enforcement, as was reported in the 2021 TIP report. If we could move on to the next slide. So earlier we covered the common risk areas, which were similar across sectors. And because palm oil plantations are quite unique, we're also just covering a little bit of the risk areas which are specific to palm oil plantations. So this is due to the palm oil industry's nature of work and locality, which presents additional challenges. So the first one that we have seen is the lack of a minimum wage, which is paid to the workers. So despite there being a legal minimum wage, we know that it's 1,002 in certain areas and 1,001 in others. The way that wages are calculated on plantation varies, even sometimes within the same company. So some plantations pay migrant workers on a piece rate, which means that the wage depends very much on how many fresh fruit branches are collected that day. But then there are other plantations who may pay a fixed daily wage, which means that the workers must work a minimum number of days a month in order to make the minimum wage. So for example, if the worker is ill and does not work, then he's not paid. So what this ends up with is that workers are not getting the minimum wage. And this again is unlawful because the law is very clear. Whether you calculate according to piece rate or a daily rate, you must ensure that minimum wage is paid. Secondly, of course, something which is quite specific to industries which are remote, for example, palm oil, plantations, or even fisheries. It's the physical remoteness of the work sites that have added risk. So freedom of movement here becomes a larger issue due to the location of the work sites. The closest towns, for example, may be just too far away for a worker to venture to without transportation provided by the employer. So then they are reliant on the employer to provide that transportation. And what that means also, of course, is that access to basic necessities then becomes an issue because there is limited access to basic groceries, including fresh produce. If they can't get out, then they are very reliant on what is brought in. So workers have no choice but to purchase these necessities from the on-site stores, which are provided by the employers or third-party contractors, where the prices may be excessive. But because the workers can't go anywhere else, they can't get food from anywhere else, they are forced to deal with that situation the best that they can. And some plantations may also be so remote that they do not have access to mobile phone coverage, which then increases the risk of isolation for migrant workers, in turn rendering these workers more susceptible to exploitation, because if they're exploited, they can't tell anyone. And lastly here is the intermittent access to electricity and water. So similar to mobile phone coverage, the remoteness of plantations may also mean that the migrant workers do not have effective access to potable water or electricity, especially where the plantations rely on generators, where there's a finite amount of electricity. Okay, so I just have one last slide now, which is sort of like a bonus slide. Carl, next slide, please. So these are the newly tabled amendments to the Employment Act of 1955. This was just tabled on the 25th of October of 2021 by the Human Resources Minister. It was the Employment Amendment Bill of 2021. And there were quite a few amendments there, including on sexual harassment and discrimination. but the ones which I'm going to cover here are the ones which are most relevant for the employment of migrant workers. So if you're interested in the amendments, then you can go look at the bill itself. But just to start here, so now what is required is the prior approval of the Director General of Labour in order to employ migrant workers. So the bill introduces a new requirement for this prior approval, which was not needed before. So before, the employer was only required to furnish the particulars of the migrant workers employed to the Director General of Labour within 14 days of the migrant worker arriving in Malaysia. So the proposed amendments now require the prior approval of the Director General to be obtained prior to the employment of the migrant worker, and the employer's application for approval is subject to the following conditions. One, there must not be any outstanding matters relating to any decision, order, or directive issued under the Act, so that's the Employment Act, that there is no outstanding matter or case relating to any conviction of offence under the Employment Act and any other specified legislation. And lastly, the employer cannot have been convicted for any offence under any written law in relation to trafficking in persons or forced labor. So if you have any of this sort of charges pending, then you will not be receiving this approval to employ migrant workers. And the failure to obtain this prior approval of the DG of Labour will attract a fine of not exceeding 100,000 ringgit or imprisonment of a term not exceeding 5 years or both. So the bill also provides that where an employer terminates the employment of a migrant worker, the employer has to inform the DG of Labour within 30 days of termination. If the migrant worker is the one who terminates the contract or he absconds, then the employer only has 14 days from the date of termination or absence to inform the Director General of Labour. Another interesting new addition is the bill now creates a new offence, which is specifically for forced labour. And as provided in the bill, forced labour is where any employer threatens, deceives, or forces an employee to do any activity, service, or work, or prevents the employee from leaving before the activity, service, or work is done. So this offence carries a penalty of fine of up to 100,000 ringgit or the imprisonment of a term not exceeding 2 years or both. So this is interesting also because another risk which we have seen in employment contracts for employers here is that often the employer actually does not put in the termination clause for the workers. So as you know, under the Employment Act, as long as minimum notice is provided, the worker can terminate the contract. This is often not included in the contract, which leads to the migrant worker thinking that he cannot terminate the contract. So now there is also this additional offense where if you prevent the worker from leaving, then you can be charged. Another interesting amendment is that there is now a reduction in the maximum weekly working hours. It used to be 48. Once this is passed, it will be 45 hours a week. And the next one is on wage-related offences. So the court can order an employer to pay any payment that is due to the worker, and failure to comply with such an order empowers the court on the application of the worker to issue a warrant or a levy for the employer's property, so that the payment due can be gotten by way of distress and sale of property, or by way of fine provided under the Criminal Procedure Code. So so you have to pay your workers. If you don't pay the workers, then the court can force sale of your property to pay the workers. And lastly here, the general penalty for offences used to be 10,000. It has now been increased to 50,000 because there are a number of offences under the Employment Act where there is no specific fine. So where there is no specific fine stated, it used to be 10,000. It is now 50,000. Okay, so I think I conclude my session here. Carl, are there any other questions that are in the box?
Yes, many.
Oh, okay.
Okay, let's pick out some questions first, and then people can ask and clarify the others, or perhaps verbally. Okay, what is the repercussion of Malaysia being downgraded to tier 3?
That's a good question. The repercussions of Malaysia downgraded to tier 3 is that Malaysia can now potentially face sanctions by the US. So that is why it's important to not be on tier 3. In fact, Malaysia had already been given a chance in the sense that you can only remain on a tier 2 watch list for 2 years, after which you'll be automatically downgraded to tier 3. However, we were actually on the tier 2 for 3 years because because the US State Department sort of allowed us to remain on tier 3 for a third year instead of automatically being downgraded because they saw some efforts. However, after the third year, the efforts were insufficient, and then we were then downgraded to tier 3.
Next question. Is it mandatory for employers to pay the salary into the workers' bank account, including informal migrant workers?
So my simple answer to that is yes. The Employment Act does require that workers have a bank account and that salary be paid into the bank account. This is so that it's easier for the government to track the payment. So for example, if the worker says that you haven't paid, and then the Labor Department comes to investigate, you can't prove there's an account, you can't prove money going into the account, then it's easier to prove that you did not make that payment. So, for your own security as well, it makes sense to have those payments and to be able to show that the money is going in properly every month. One of the new suggestions by the Minister of Human Resources is that they want to develop an e-payment system where so the details are not set in stone yet, but essentially it will make it easier for the government to monitor the payments that are being made because everything will be captured in this e-system.
Next question. Can you comment on the capacity of Malaysian unions to help and support migrant workers due to language barriers?
That's a good question. I think like everything else, it's very much dependent on resources. I think the unions are trying. I just saw a statement from the MTUC branch in Penang that was released yesterday. Again, asking the government to investigate seriously these offences of forced labor, because no one, whether citizen or non-citizen, should be subjected to forced labor. The issue of a language barrier, of course, is very, very true. And, that is similar to the problems that migrant workers face with our courts, for example, or with the hotline that the Labour Department has, because we know there's a hotline, but the hotline's in Malay. So how are migrant workers going to complain if they can't even communicate with the person taking their complaints, right? But as far as we know, the MTUC actually has MRCs, Migrant Resource Centres. So these Migrant Resource Centres do provide support to migrant workers who may need help. And for example, in the case which I told you about just now, where 50 ringgit was deducted from the workers, it was actually the union who brought this to the Labour Department and pushed for action.
Are migrant workers, do they have the right to choose not to vaccinate? I assume this COVID, or is it a must in order for them to continue to work in Malaysia?
Carl, please correct me if I'm mistaken. Because I think the issue is that vaccination is still quite a sensitive issue in the country. As far as I'm aware, there has been no mandatory provision for vaccination. I think you can still choose to not be vaccinated if you want. The government has not said that everyone must be vaccinated, although it's encouraged. If you have migrant workers that are afraid to be vaccinated or don't want to be vaccinated for whatever reason, I think it's important that you perhaps work with civil society organizations to hold awareness sessions for these migrant workers. So, for example, actually, why don't you email us as well? Because we have been working with a few companies who are facing such issues. And what we have done is we have been sharing resources with the companies so that they are able to encourage their migrant workers to get vaccinated. So we have, for example, we have videos from celebrities from their countries of origin asking them to get vaccinated. Just simple things like that. So yes, so if you're facing those issues, Carl and I will put our email addresses in the chat box. Please reach out to us. If we can support you with materials, then we will.
Thanks. And next, I am interested to know the services provided by IOM to address these gaps and issues.
Oh, that's going to take me another 2 hours. So just basically speaking, we do in Malaysia, we do provide support to companies. So for example, we help them develop policies if they don't have policies. If they already have policies, we help them identify gaps in their policies so that they can improve on their policies. We also conduct risk assessments, as I shared earlier. We have something called the labor migration process mapping, where what we do is we conduct worker assessments. We interview your workers, we interview your recruiters in the countries of origin. And here, if you have recruiters here, we also interview your management. And then we are able to hopefully from those assessments, identify the gaps within your systems and then help you and support you in addressing those gaps as well. We also have training workshops like this one. So this one is obviously quite a simple one because I only had 1 hour, Carl has 1 hour. So we've got specific workshops on ethical employment. We've got specific workshops on ethical recruitment as well. Those are separate topics. Carl, do we have anything else?
Yes, quite a few, but let's just pick out a few and group them together. So a lot of questions on passport retention. What if, so 2 points to that. What if it's for safekeeping with letter of consent from migrant worker, number 1. And number 2, what if in the safe box where we give workers, the key is being held by the workers, but the room is locked, where they need to inform the office before they want to access the passport. So there's two situations.
Sure. Okay, so the Passport Act is very clear. It doesn't afford for any exceptions except that it must be lawful. So the simple question here is, the simple answer here is that no, you cannot hold your worker's passport, even where you have the consent of the worker. If you go home today and you open your passport, if you open your passport, you will see that the passport doesn't belong to you. The passport belongs to the government of Malaysia. Similar with the worker's passport, their passports do not belong to them. They have no right to give you consent to hold their passport. And the law is very clear. You shouldn't be holding any passport that doesn't belong to you. So don't hold the passports. Second question, you need to make sure that the workers have effective access to the passports. So yes, I commend you for providing safekeeping lockers for your workers, but they must be accessible 24 hours. And the worker shouldn't have to ask for permission to access the room. Also, another thing is, for example, if you only provide lockers at the work site and your workers stay half an hour away, then that is also not effective access, because if the worker needs his passport after work, then he has no access to the passport. So that is not good either. So you need to make sure, best practice, you have lockers at both areas, and the workers should have their passports at all time, access to the passports at all time. And this benefits you as well. When I was a lawyer, what I used to see in court a lot was migrant workers being charged for not having their passports. And their employer would be there and their employer had their passport. And then the employer told the judge, we have the passport was with us. And then the prosecution would say, but now we have to verify the passport. It takes months for some reason to verify that passport. So for those 2 to 3 months, your migrant worker remains in prison for something that's not his fault, and you lose a precious worker. So it's so much easier in the long term to just not put yourself through that hassle unnecessarily.
Next question. What is your opinion where workers request for overtime? They want more salary, but it exceeds the law stated for overtime.
Carl, I think you can answer that question.
Well, Asmawati, just to provide some context, right? We know that there is a lot of demand from workers for overtime. And already we know that the laws in Malaysia that allows for overtime on top of regular working hours exceeds the international standards. So it's already a lot. The fact that they ask for more overtime, you cannot basically give more than the allowed of the law. But the fact that they ask for it, you must look at the root causes of this issue. One, it is most likely that people are not paying the workers a living wage, right? And therefore, this is one of the main reasons why they ask for more overtime, for more salary. And it is also related to the fact that they had probably paid a lot of recruitment fees, right? And so are stuck in a situation of debt bondage. And so there's like a constant cycle. You're stuck in a situation of debt bondage where you have to pay huge debts. And then you have to, your pay wages, your regular wages are low. So they, in a way, forced to ask for more overtime beyond the law, right? And so one of the indicators of forced labor internationally is excessive overtime. But you cannot just, for example, solve it by giving them less overtime, because then it's a problem of their wages, right? So you must always do a root cause-based analysis through due diligence, a management system approach where look at proper living wages for them and also remediate and make sure that there is zero recruitment fees paid by the migrant worker. So that's my response for that question. Next question, John. Can canteen or sundry shops, I assume groceries and things, the debts by workers, be deducted from the salary?
No, it cannot be deducted from the salary unless two conditions are fulfilled. The first condition is that the migrant worker asks you to do it. And even where the migrant worker asks you to do it, you need to get permission in writing. Both must be in writing from the Director General of Labour. So if you don't have these two things in writing, you cannot deduct from the salary. Another thing that I also perhaps want to add on here, because this is related to the plantation issue just now, but also we have seen it happening in manufacturing companies, even in urban areas, is that they have this system where they've got the canteen or the sundry shop, and then they deduct from the salary, right? So first of all, you need to make sure, are the prices market rate, are the prices reasonable? Because otherwise, again, is exploitation of the worker. And secondly, when this is deducted, are the deductions clearly set out to the workers? Do you itemize it or not? You can't say, oh, okay, it's the end of the month, you bought $300 worth of groceries, I'm going to deduct $300 now. No, you must specify, okay, cabbage, I don't know, $2, rice, $5, everything must be specified. And of course, like I said, the most important thing, two conditions fulfilled. The migrant worker must have asked you for it, and the Director General of Labour must have given his permission.
Thanks, Joanne. I think that's all the time we have for now, because we need to prepare for the next presentation at 11. Perhaps, sorry, couldn't answer all the questions, there are many, but perhaps you can also email Joanne or myself of any questions you may have or for further engagement. Perhaps I'll pass it back to Alia. Thank you.
Okay, yeah. I think Mr. Robert, do you have, are you okay? Do you have a question or clarification to make? I see his hand raised.
Yes. My question to Joanne was not answered earlier. She's talking about the Malaysian going to overseas as a migrant worker. It would be actually the same thing actually is happening, like those migrant workers coming to Malaysia. I see a lot of those documentary films, whether it's in Australia, United States, or in the EU side. Malaysian are also been humiliated in the prospect of actually is that of this happening, just like what we are treating the migrant workers in Malaysia. And also another thing is actually is that from my interaction with all these agencies, sorry to say is that actually we are treating them like dogs, which is actually they are human, and we should not do that way, because they are coming here to work, to support the industries, to support us in whatever way that these are called the 3D jobs, where it's actually that we are not working along this line, whereas we Malaysians are going over to other countries also doing 3D jobs. That's where actually this such thing is happening. So how would you comment on this, Joanne?
Thank you so much, Robert. I think that's a very good point that you raised. I think that is sort of the mentality that we need to have, right? You know, I'm sure some of us, we may have friends, we have, you know, sisters, we have maybe family members who are working overseas, and you know, the simple question is, you know, do you want your sister or your brother, for example, to be treated that way if they went overseas to try and find a better life? You know, why do you treat people here this way, but then you think that Malaysians shouldn't be treated that way? So, Mr. Robert, I think that's a great question, and I agree with you. I think that no matter who you are, no matter where you go, people need to treat you with dignity and with respect. You know, at the end of the day, everyone just wants an honest job so that they can make a good living for themselves, for their families, and yeah, there is no reason why we treat someone who's not from here as a second citizen. Yeah, second class citizens. Sorry, I mean, yeah.
So much.
Alia, perhaps I pass it back to you. I think that's perhaps a short break before the session at 11. Yeah.
Yep. Yep. So Ms. Joanne, feel free to go grab a coffee as well for yourself. Everyone else, as I've mentioned in the chat box, please go and take your break. Go go to the washroom if you need to. Grab a coffee or breakfast if you haven't. And if you also haven't done so, please sign in your attendance in the link that I've pasted in the chat. Thank you. We'll also resume, I think, at 11 a.m. Yeah. All right. I hope everyone had a nice break. Mr. Carl, are you ready to go?
Yes, thanks, Alia.
All right. Okay. So I will briefly just introduce Mr. Carl to everyone. So Mr. Carl will be doing a session on forced labor and the global legal frameworks for Malaysian exporters. So Mr. Carl is a national program officer in the International Organization for Migration, along with Ms. Joanne. So he works on counter trafficking and labor migration and is part of the CREST program, as well as the IRIS program, as mentioned earlier with Ms. Joanne. And these programs aim to uphold the labor and human rights of migrants, strengthen ethical recruitment, and improve employment practices in partnership with businesses, governments, and key stakeholders. As a former prosecutor with a Master's of Law, LLM, and a background in independent research, he is experienced in the areas of international law, law enforcement, and human rights. So the floor is yours, Mr. Carl.
Thanks, Alia, for the kind introductions. Good morning, everyone. If I may just ask Joanne to put the screen on full size, please.
Is it still not on full size?
No, not yet.
Okay, it's on mine for some reason. Hold on, let me try again.
Excellent.
Is it working now? Thank you.
Thank you. Okay, before we get, can you go back to the previous slide, please? Sorry. Yeah, so today, thank you everyone for joining us. We have today's topic is around modern slavery related laws, yeah, around the world and global legal frameworks and what exporters need to know. We'll be looking at the current situation and the future situation. And this won't be a kind of legal technique or method kind of training, but just a kind of big picture view of things, yeah? So perhaps to wake everyone up, can I get some answers in the chat box on this question, which many of you will be very familiar with. How many Malaysian companies in total have been affected by US Customs and Border Protection import restrictions? So these are your withhold release orders and the bans, yeah? So how many in total, yeah, in the past, I don't know, few years do we have? Let's see some answers in the chat box. Whoever wins will bank in, the university will bank into you a lot of money. Okay, we have 3, we have 7, we have 5, we have 3. Okay, 3. Someone asked, does this include TG? 5. Okay, interesting. Okay, so this is 6, unless there was a new one that I lost count of. Yes. So, okay, so this is the big hot topic, right, at the moment, not only in Malaysia, but regionally and around the world. The US CBP enforcement bans related to forced labor. In Malaysia, actually, the answer we have throughout the few years, yeah, there's been Smart Glove, Top Glove, Sime Darby, FGV, Supermax, and WRP. But Top Glove and WRP has been lifted. So altogether, it's still 6. Yeah. So whoever answered C, open your bank accounts later, quite a bit of money coming in from you. But also, we know as well that they've been investigating 2 more companies, yeah, in this year, in fact. One is ATA and another is IOI. So altogether, we could look at the numbers increasing, in fact, yeah. Okay, thank you for that participation. Next slide, please.
Is it working?
No, it's not. Are you resharing? Sorry for the technical issues. Now we see presenter's view. Maybe just go escape and yeah, close this off. And at the bottom right corner, you see the presentation button. We lost the slides again. Maybe maybe I can share mine, see how that works. Sorry, everyone. Okay. Can everyone see my screen, full screen?
Yep, looks good.
Okay, let me just handle it from here. Okay, sorry, everyone. Okay, so in this presentation, we're looking at modern slavery related laws around the world. And there will be three kinds of laws in this presentation, yeah, that we'll be dealing with. One is import restrictions. For example, the US CBP bans that we just talked about, yeah. And number two, which is the most popular kind of laws that are around the world these days related to modern slavery, which is mandatory disclosure requirements or reporting, yeah, mandatory reporting requirements, such as in the California state, United Kingdom, and Australia. And finally, we have a look at what I see as the future of laws related to modern slavery and human rights, mandatory human rights due diligence, and a current example of France. Yeah, and we'll go deeper into these as we go along. However, just to note that while mandatory disclosure requirements, some people says it's about human rights due diligence, it doesn't necessarily mandate due diligence, but substantive reporting or substantive disclosure is very difficult without first carrying out human rights due diligence. So human rights due diligence is like one step above disclosure and reporting, really. Okay, so now you can see this map, yeah, of what we're going to look at today. We're going to look at California, where the Transparency in Supply Chains Act, which is a disclosure law. We're going to look at the US other laws stated there, which is related to the US CBP enforcement bans. We'll look at the UK and Australia as well, which are disclosure-based laws. And finally, France, as I said, mandatory human rights due diligence. Now, a similar law, disclosure law, is also being tabled in New York State in America, currently going through the legislative process. And what's interesting is that while there are different jurisdictions, yeah, requiring disclosures, they can be quite different in terms of their requirements. However, but they can also be quite similar. So what some companies have done is that they make a single disclosure statement covering all these different jurisdictions, especially for big multinationals, yeah, who are covered under these different countries. And they generally achieve this by disclosing more information than is required under the respective legal requirements of each country. Now, there are currently no specific regulations in the UK, Australia. Sorry, is there someone speaking?
Sorry, I think someone accidentally unmuted themselves.
I see. Does everyone mind just muting, and we'll handle questions later on?
Yeah.
Thank you very much. Now, there are currently no specific regulations in the UK and Australia and France that aim to restrict imports like the CBP does in the US. But there are issues wherein federal government contracts, yeah, are looking to be withdrawn or have been withdrawn from contracts with suppliers who are found to have produced goods for forced labor. Now, let's look a bit at the big picture of these modern slavery laws. Yeah. So what is this purpose? So it's essentially to drive corporate action to look into their supply chains and work conditions to eradicate modern slavery, forced labor, and child labor. It encourages as well active supplier engagement, and this puts a lot of responsibility to communicate expectations to supplier. So who has the most responsibility here is usually the big companies, right? It's the buyers, it's the parent companies, yeah? And this may even require supplier responsibility in contracts. So what are we looking at? Here, meaning maybe your customers will put in the supplier contract saying they require third-party external unannounced audits, or they require annual reporting on environmental, social, governance, or human rights issues to them from the supplier. Now, most of the laws right now, as I said, require reporting, and this encourages transparency. one of the biggest issues we have today in the world of business and human rights is lack of data. A lot of what happens within companies and businesses are opaque. Yeah? There are barriers where we cannot access data, information, and therefore cannot work on advocacy around it, evidence-based, and help to handle issues. Yeah. So one of the key things that we're trying to push forward in is transparency. This helps to empower consumers and investors to choose ethical businesses when they see, for example, information and data on companies saying, hey, this aligns to my values, I'll support this company, or this does not align to my values, you know, I will boycott their products, for example. And it also helps to raise awareness within businesses as laws require top management to sign off on these reporting disclosures. And what's interesting is that this requirement for top management to sign off on reporting now does not give the opportunity for top management to then say, oh, we weren't aware of issues on the ground. So this connects the HQ, the headquarters of businesses, directly to issues on the ground. They say that, hey, you know, you have to be responsible for this, you have to be accountable for this, and you have to know what's going on the ground. Often there is a disconnect between what's happening in the nice air-conditioned offices in the headquarters and the ground in plantations or construction sites, for example. And finally, allow consumers and civil society to hold businesses accountable through advocacy based on information provided, where whole campaigns may be and have been launched on data and information provided by companies. If they're not doing enough, if they're misleading, etc., and we'll look at some of these cases later on. Why should businesses care? It is obvious. There are legal risks in terms of authorities taking legal action against you, which we'll be exploring, stakeholders suing you, victims claiming from damages. Yeah, there are of course financial risks related to that, where you need to remediate issues where you didn't find out about, you didn't identify. You have to pay fines of damages for violations of rights, and you can get your contracts terminated by customers or buyers, as suppliers. Also reputational risks, of course, as we are now moving in a world of active advocacy, where all kinds of stakeholders from civil society to NGOs to migrant workers will act on you if you fail to follow and move with the times. Yeah, and you will lose the market share from all these activism and enforcement. Now, the other, of course, the most essential part is that businesses should care, because there is a responsibility to uphold human and labor rights of all workers, including migrant workers, in line with the UN guiding principles on business and human rights and the Sustainable Development Goals. Now, let's go first to the US legal framework. So there are 2 points here that we want to look at. One is the US CBP laws under the Tariff Act and Trade Facilitation, where they can detain or seize merchandise produced partly or in whole by forced labor, and these are enforced by US CBP. And number 2 here is the California Act on Transparency Supply Chains, which requires public disclosure and can be enforced by the Attorney General of the United States if there is non-compliance. Now, in determining whether there is forced labor or modern slavery, the US Customs and Border Protection and other enforcement authorities in the UK, US, and Australia will look at the presence of the 11 ILO forced labor indicators, which I'm sure a lot of you have been familiar with or have been explored in other trainings. And also the international definition on forced labor. So the first part here is import restrictions, US Customs and Border Protection. So let's go into this. So for CBP enforcement, now it's worth mentioning that the US Department of Homeland Security has made forced labor a priority area in their strategic plan in 2020 to 2024. This means increased enforcement in this area of modern slavery and forced labor. And forced labor is defined by the US CBP as per international standards, which is all work or service which is exacted from any person under the menace for any penalty for its non-performance and for which the worker does not offer himself voluntarily. And these are also guided by the 11 indicators of forced labor by the ILO, when determining whether goods are made by forced labor. Now, what's interesting is that Malaysia, if you look at the US CBP website and the findings and withhold release orders that they put on there, Malaysia is actually number, I think, top 2 after China in terms of the number of enforcement actions being taken in the CBP. China, especially in regards to the Xinjiang region, and Malaysia has the second highest number of enforcement actions so far. So, at least we're quite good at something. This is better than our Olympics finals for badminton. But let's go into how the CBP can enforce this import bans. One is, of course, through the ever popular withhold release order, whereby upon they will issue a withhold release order where goods are detained and prevented from import into the US upon reasonable information that indicates that the goods were produced partly or wholly with forced labor. There's another way that they can enforce it. It's through a finding. And this happens when there is conclusive evidence that the goods were made with forced labor, and this results in the detention of the goods and a public notice in the US Customs Bulletin and Federal Register. So conclusive evidence here under finding is a higher standard than the reasonable information under a withhold release order. Now, how do you release goods subject to a WRO or finding? An importer may submit evidence, for example, supply chain audit reports within 3 months to the US CBP to prove that the goods were not produced by forced labor. And if subjected to the WRO, an importer may also re-export the goods to other countries within 3 months. However, if the importer does not submit evidence to the CBP, or they lack evidence to do so, the goods may be excluded from import into the US under a WRO, or seized. Seized here meaning the US government takes possession of the goods under a finding. So that's really quite critical. And it should be known that false statements from the importer may result in criminal prosecutions by the US government. And from what we've seen so far in Malaysia, common indicators which the US Customs and Borders Protection has identified as forced labor indicators in Malaysia has been around recruitment fees and debt bondage, housing standards, or rather deplorable housing standards, excessive overtime, disproportionately affecting migrant workers, as we discussed earlier, and also retention of identity documents, including passports. Now, here is just a kind of brief overview of the process. So CBP can issue a WRO finding, which results in the detention of goods. Then there will be submission of evidence by the importer, where this applies to both the WRO and finding. If it's a WRO, the importer may also re-export the goods elsewhere. And finally, the goods may be released if the evidence is sufficient, or if the evidence is lacking or there's no evidence, may be excluded from import. That means it cannot go into the US, or it can be taken possession by US government and seized. So, and this is, of course, the issue that a lot of companies have been struggling with in Malaysia, especially, where there is a petition, right, where there's a WRO or finding against them, and they need to modify it, basically to release the ban. So what do they need to do? This is been taken from US Customs and Borders Protection flyers, to say that you should include credible audits, which includes unannounced independent third-party audits, where all indicators of forced labor, as I mentioned, are addressed, and there are also interviews completed of your workers, including migrant workers, in their native language. Yeah, and should also come up with a corrective action plan, which includes actions required to remedy identified forced labor indicators, verification and implementation of the forced labor indicator remediation, clear timeline of milestones to complete, and what consequences there are if no actions have been taken. Yeah. So essentially, they want you to really handle those forced labor indicators in your company, come up with a clear plan, and address them, yeah, until there are no longer forced labor indicators in your supply chains. Now, let's go on to the next area of topic, the most popular now around the world, mandatory disclosure requirements. Yeah, here we'll look at California, UK, and Australia. Yeah. So for first, now I'll skim through some of the details, yeah, because you don't need to know everything. What you need to know is kind of big picture approach to this. California Transparency Supply Chains Act is the first act in the world to require disclosures, yeah, in terms of to eradicate slavery and human trafficking from company supply chain. So this has been the example for the UK, US, and other countries we will be discussing. So that's why I thought to put this here. This act applies to retail sellers or manufacturers that does business in the state of California with an annual worldwide gross receipts in excess of $100,000. Yeah. And even if the law does not directly apply to companies, businesses with any connection to applicable Californian businesses should be prepared to respond to requests for information from them, right? So if a business, a buyer, a customer, for example, comes under this law, they may be required to ask information from you as exporters, as suppliers in their various tiers, yeah, because they need to fulfill the requirements of this act. So here the disclosures are required to be published on the company's website or given in written form to consumers within 30 days upon their request. However, there's no specification on how often disclosure must be made or updated. And we'll see later some examples of disclosures. Yeah. So 5 areas of disclosure that are required under this act is verification, audits, certifications, internal accountability, and any training which the company provides to employees and management in regards to the topics of human trafficking, forced labor, modern slavery, human rights, etc. Legally, though, interestingly, it is compliant. You're still in compliance with the law if you disclose a statement stating that, so this one-page statement with one line saying, no steps were taken to address modern slavery in the areas above. You can actually do that. However, then if your consumers or other stakeholders look at that statement, then you better be prepared for the backlash, you know, that you are not serious about handling issues in your supply chains, and therefore more attention may be put into your operations and supply chains. Next, let's look at the United Kingdom Modern Slavery Act. So this came after the California Transparency Supply Chains Act, whereby sections 54 requires certain organizations to publish a slavery and human trafficking statement annually, where they should include steps taken to address these issues, if any have been taken, and should be published within 6 months of your organization's fiscal year end. Yeah. Who does this act apply to? A body corporate or partnership, wherever it's incorporated, that carries on a business or part of business in the UK, which supplies goods or services with an annual turnover of £36 million or more. Those who do not comply with the disclosure requirements in the UK, who come under those this act and do not comply, so basically those with annual turnover above £36 million, the government may apply to the court to force the businesses to comply with the law, with a possibly unlimited fine for non-compliance. But this has not been done yet, and it's been there's been some discussion about the need to increase the enforcement provisions to give this act teeth. The government plans to also publish a list of non-compliant businesses in the future, and there are proposed amendments to this law where there will be recommended areas to cover under this disclosure will now be made mandatory, where there will be a single reporting date for all business entities, have the law extended to public authorities as well, and there'll be a central registry where there's a central registry now, but companies give it voluntarily, but they intend to, under the amendments, to make it mandatory for companies all to submit to the central registry website under the government for everyone to be able to see all the company statements under one registry. And they also intend to have civil penalties under this amendment. Yeah. Now, how do you make disclosure right now? It should be easily accessible from the homepage of the company website, and it should be approved by the board or equivalent and signed by a responsible member. Here, for example, the director. As I said, top management must be aware, and this is part of the mechanism of the whole thing, framework. And if the company has no website, you have to provide written information to those who ask for it within 30 days. Yeah. So these are the recommended areas to cover, which is currently not mandatory. But as I said, there are laws being proposed to amend to make these mandatory. So one is the organization structure and supply chains. Number two, what policies you have in relation to modern slavery and human trafficking. Third, what due diligence processes you have taken. Fourth, what are the results and findings of your risk assessments and management. And next, what KPIs, what key performance indicators do you use to measure effectiveness of the steps being taken to address such issues in your supply chains? And finally, again, what trainings on modern slavery and human trafficking have you provided or intending to provide to your staff and employees and workers? So as you can see, there are some things that overlap with the California law as well, and you will further see further overlap later on. Now, as for the UK experience, smaller organizations which do not come under the £36 million threshold are also being commercially compelled, forced to prepare and publish annual statements under this law in order to be able to participate in procurement exercises and or satisfy larger customers or buyers, suppliers' codes of conduct. Yeah? So even though the law does not require the smaller organizations to release disclosures, but maybe your buyers in their code of conduct or contracts with you require you to do it voluntarily. And this volunteer provision is also encouraged by the UK government. Yeah? Thus, your organization may have to make disclosures, even if you are not bound by the UK law. Next, we'll move to the more recent and perhaps the strongest amongst the three in terms of legal weight and teeth, is the Australian Modern Slavery Act 2018. Yeah. So this act is also an act that requires disclosures, establishes annual reporting requirement for certain businesses and the Australian government on actions to assess and address modern slavery risks in their global operations and supply chains. Who does this act apply to? Australian entities or those which undertake business in Australia in that financial year with a minimum consolidated annual revenue of AUD $100 million. Those who do not comply with it, the government may publicly name and shame the business. Yeah, I don't think they have done so, but this is indeed the intention and is allowed for by the law. And how to make the disclosure? Companies who are under this law must submit to the government for publication on an online central register, as the UK government plans to do, within 6 months of the business fiscal year end. Statements must also be approved by principal governing body of entity and signed by member of that body. For example, approved by the board and signed by the same as the rest, of the other laws. And there are 7, as opposed to the UK law, which has only recommended areas to cover. Australian Modern Slavery Act has 7 mandatory reporting criteria that you must put in your statement. Number 1, identify reporting entities, which are under your group of companies. And you have to describe the structure, operations, and supply chains of your group. And then you have to identify and explain the risks of modern slavery practices in the operations and supply chains. You have to show the actions you are taking to assess and address the risks of modern slavery. You have to show how you are assessing the effectiveness of those actions. So here is monitoring and evaluation. And next, you have to show how you consulted on producing the statement, you consulted with any of the entities you own or control, and other relevant information. So other relevant information here could include whether your company or business has supported the development of legislation on modern slavery in another country. So they see your active advocacy around the issue, see how much you care. Whether your business has participated in external forums on modern slavery to help improve awareness in the business community. Whether you have partnered with CSO, civil society organization or industry bodies on these issues. Whether you have contributed to addressing the root causes and structural factors that contribute to these issues. And finally, if you reported on a situation of modern slavery in a previous statement, updates on how the situation has been addressed. So this is the Australian example. And now I'll take you to see actual disclosures a bit. And this can be found in the Australian Government Registry website. So here you can see Lenovo's. This was published for year 2021. And look at the first few lines. This statement confirms the steps Lenovo has taken during the fiscal year, blah, blah, of Section 3 of the California Transparency Supply Chains Act, the UK Modern Slavery Act, and the Australia Modern Slavery Act. So as I said, some companies take the approach of compiling all these jurisdictions and coming up with one statement so they can reuse it. What they need to then do is make sure that all the requirements under each of those laws are covered under this one statement. So usually they tend to give more than is required under certain jurisdictions. And sorry, can everyone mute their mics, please? Thank you. We'll deal with questions at the end, and have some discussion as well. You can also be very simple in your disclosure. So Lenovo has this about 7 or 8 pages, this document, and you can see here how they identify their risks. So it's quite general in the sense that Lenovo's procurement activities include both direct and indirect procurement. The risk is largely in the external supply chain for direct procurement. It exists because many suppliers have access to large, low-skilled labor pools that are vulnerable to exploitation. So without, and also, if you see the last few lines of this identification of risk, Lenovo's life management conducts self-audits, Lenovo corporate internal audit, independent audits, and receive RBA independent third-party audits. So within a few paragraphs, already they covered this fact. So their statement is quite simple and to the point. And as you can see, after the 7 pages, at the end, the director has to sign it to show that top management is aware and takes responsibility of these statements. Now, let's compare this now to the Kathmandu, which is a outdoor apparel company, modern slavery statement under the Australian Modern Slavery Act as well. In comparison to Lenovo's 7 or 8 pages, Kathmandu takes a more detailed approach. It's just choice of the company and does 61 pages. Look at the table of contents. So whereas the whole statements of other companies is 7 pages, in Kathmandu's statement here, if you look at number 5, chapter 5, the risks of modern slavery in Kathmandu operations and supply chains, even the risk there is 9 pages, is more than most companies' statements already, right? So they provide a lot of detail, and you can see the kind of usual structure. First is the structure, operations, and supply chain of the companies under number 4. Then you identify the risks under number 5. Number 6, the actions. Number 7 will be monitoring and evaluations. And they even added number 8, special COVID-19 response. And number 9, consultation process, which I'll show you. So here you can see the screenshot that I took from Kathmandu's risk chapter. See how they organize their geographic risk of modern slavery by country first. So you can see China there has a orange, which is a high-risk country, and they detail all the issues related to forced labor and their companies in China. And then after that, you'll be able to see Vietnam and how their work in Vietnam and what the risk level is, and also Indonesia. And they go through this to all the countries where they are involved in. Yeah? So it's very detailed. Yeah? And then after that, you can see also the business risk of modern slavery under 5.4 at the bottom right corner. They go into their various tiers, show the visibility. For example, Kathmandu, full visibility is currently limited to tier 1, assembly, cutting, and sewing. Kathmandu is only partial visibility into tier 2. And on the next page, you can see tier 2, tier 3, and 4. So even under tier 3 and 4, they will say Kathmandu has very little visibility into tier 3 and 4 and cannot reliably state what the risks of modern slavery are in this part of supply chain. Yeah. So, and then they deal with all these problems in the next chapter in actions to be taken and monitoring and evaluations. Yeah. So it's quite detailed, not only by region, by country, by areas of operations, but also the various tiers of suppliers. Yeah. And you can see that they have a special chapter on consultation process as well, where they list down all the different stakeholders and CSOs that they engage with, including Beast Slavery, Mekong Club, New Zealand Human Rights Commission, yeah, their suppliers, Fair Labor Association. They list down all their third-party consultations in the statement. So let's now move on to the final chapter of the legal frameworks, mandatory HRDD. Now this and HRDD is an ongoing risk management process that a reasonable and prudent company needs to follow in order to identify, prevent, mitigate, and account for how it addresses its adverse human rights impacts. It includes 4 key steps: assessing actual and potential human rights impacts, integrating and acting on the findings, tracking responses, and communicating about how impacts are addressed. This is from the definition of the UNGPs, yeah, Guiding Principles on Business and Human Rights. And HRDDs, human rights due diligence, concerns risk not to your business, but risk to people. And that's an important distinction to make. And why is there mandatory HRDD? And why is what I think and what many think that the world is moving towards more and more so in terms of regulation? There's an understanding, popular understanding, that now self-regulation and voluntary measures to foster corporate respect for human rights have proved insufficient thus far. Therefore, a binding or mandatory framework is needed to protect people and the planet and ensure fair competition for companies who act responsibly. And that's why mandatory HRDD now is gaining discussions on the ground and in high-level spaces where it hopes to enhance accountability and transparency of business operations and supply chains. So let's look at an example of France, yeah? The Corporate Duty of Vigilance Act, 2017. This applies to all large French companies, over 5,000 employees in France or over 1,000 worldwide, to undertake due diligence with the companies they control, closely work with, and all contractors and suppliers. Your due diligence concerns human rights and environment issues, and the plan should identify, analyze, and map the risk connected to companies' activities, and should include measures to mitigate this risk. Now, the difference as well between normal disclosures, like in chapter 2 that we dealt with, the plan must be implemented under HRDD laws and monitored and be available publicly for stakeholder participation and review. Yeah? Now, implementation, again, is crucial as it differentiates this from mere reporting and disclosures. Now, there must also be an alert mechanism under the French Act that collects potential or actual risks developed in working partnership with a trade union. So under HRDD principles, human rights-based approaches, you must work with essential stakeholders like unions and CSOs. And for enforcement of this law, the third parties outside the company may file a civil case or formal notice forcing the company to comply when they fail to comply with their plan. And there's also a possibility of penalties and damages for harm caused by the company. And there's been a few number of high-profile cases that has been launched under this act. Yeah, so plans and reports under this French HRDD Act are coming under intense scrutiny by civil society, with a number of formal notices by NGOs against multinationals gaining wide-scale publicity, including several court cases, as I said. This has enabled an ecosystem of accountability and multi-stakeholder checks and balances. So rather than the government taking action always against company, CSOs get involved, unions get involved, workers get involved, indigenous peoples get involved, and check each other because the law allows them to do so. Yeah? Of course, there are still flaws within this law, but ultimately, let's take an example of in July 2019, French NGOs and a trade union served formal notice on Teleperformance, a global call center company, alleging that the company has not properly appreciated the risks regarding workers' rights in its vigilance plan, which is its due diligence plan, and has failed to engage with stakeholders in the development of the plan as required under French law. So this is an example of how they use a formal notice to show non-compliance of a company under this act. And there is also an example of a civil suit, a court case in March 2021, where Amazon indigenous communities and an international NGO coalition filed a lawsuit against Supermarket Casino Group over alleged links to deforestation and land grabs in the Amazonian region. So these are kind of very interesting developments in human rights due diligence. Now, I showed you the current practice of those enforced, but look here. This is the future. Look at the number of space. So all the ones in orange are basically those which are either being proposed or already kind of adopted, but not enforced or being proposed. Yeah. So we have, as discussed, California, USA, UK, Australia, France, but add to that, this is a snapshot of key regulations here, not everything. For Canada, for example, has the Canada-US-Mexico agreement, which prohibits imports for forced labor and child labor produced goods, where they can seize or exclude imports depending on the situation. They did this with some Xinjiang clothing and have done this with Malaysian company Supermax. They have not banned it, but withholding all delivery pending audit, pending the audit of forced labor. And this concerns a federal government of Canada contract. And this also the same case in the NHS in the UK, where they're looking at the federal government contract over rubber gloves for Malaysia. So Canada is also looking at the Modern Slavery Act, where they will have supply chain reporting requirements like the UK. We also have, let's see, we have Norway Transparency Act, which will also a mandatory human rights due diligence and transparency obligations law, which will come in force in 1 July 2022. We have in the Netherlands the Child Labor Due Diligence Act, which will come into force mid-2022. We have Germany, which is a Supply Chain Due Diligence Act, which will come into force in 2023. This act is quite similar to France, Mandatory Human Rights Due Diligence Act, but with more higher penalties, if you don't comply. And we also have a proposed mandatory HRDD for the whole region of European Union, where they are also discussing possible forced labor bans a la US CBP. So look at the state of the world, right? It's gaining traction everywhere, and there will be more issues and more legislation, similar legislation around the world. It's being discussed in this region as well, but it's not been adopted seriously yet, but it may soon be inevitable. Now, perhaps I get some of your thoughts in the chat. Do you think the time is right to have mandatory human rights due diligence in Malaysia for large companies? Put in the chat, A, yes, B, no, C, not sure. There's a kind of just to bring up some discussions. Oh, see, we have some saying A, yes. Yes, we are too late. Some friends are saying, yes, definitely. It's interesting, right? Because even though companies know that there will be much more capacity and resources needed to push for this, they're still willing to go and move with this. Yeah? And Andrew also says all companies, that's more interesting, right? Whether all companies rather than large companies should do mandatory human rights due diligence. That's also something that we should look at discussing. Interesting that no one says, but oh, there are some not no, yeah, who say no, but let's discuss that later. For now, let's just look at some of the brief recommendations before we go into discussion Q&A. If your business is bound by any of your discussed laws, keep in mind the goal of enhancing transparency within operations and supply chains when disclosing information. Where possible, always supply more information rather than less. As a supplier and exporter, even if your business is not directly bound under any of the laws, be prepared to give information to authorities and business partners and your customers that are bound under those laws. Learn about what your customers need from you, okay? To continue that healthy business relationship and healthy business ecosystem. Other companies may also require clauses in contracts, as we discussed, with your businesses to ensure you comply with their requirements for addressing modern slavery. For example, requiring you to conduct risk assessments and due diligence. In providing disclosure and information, work towards supplying evidence to show that there is no indication of forced labor in your operations supply chains. This information could include evidence of business policies and processes, which are based on international standards, evidence of training, evidence of risk assessments, internal controls, and reporting. Now, governments generally encourage voluntary disclosures under the laws where organizations are not caught by the respective law, especially if your organization is part of a supply chain for organizations that are made mandatory to disclose. Yeah. Final 2 points. Always make sure your documentation and paperwork is up to date and ready to be shared with customers and authorities moving into the future. Work with third parties, work with your consultants, have your own HR divisions and departments. Yeah, take this seriously, work with unions, work with worker representatives, work with CSOs, engage key stakeholders, and conduct human rights due diligence before it's too late. Yeah. Now, we can share the slides after with further guidance here on FAQs on US, UK, Australia, and France. And finally, I'd like to leave you with this before we go into a Q&A. William Anderson, in-house counsel for footwear brand Adidas. In short, it is not a question of if, but when such laws will be in place and how they will impact current business operations and practices. So if you leave this today with nothing else, just remember that this will be coming to our shores, whether mandatorily or otherwise. Yeah, and we will all have to look at business in a new way, placing migrant workers, and people and planet at the forefront of our business. Yeah, in line with our goals for profit as well at the same time. Thank you, and perhaps I'll move on to the Q&A and discussion now. We've got about 10 minutes. Joanne, would you like to perhaps highlight some questions in the chat?
Sure.
Thank you.
There are quite a lot of questions, so I'll just try to, okay. So there's one question here from Linia. She said, can you comment on the reimbursement to migrant workers of the illegal recruitment fees by employer when it was paid to agents, sub-agents in the home country and not collected by the employer? Is this reimbursement one of the requirements by the US CBP to discharge an employer or company on the WRO and other findings.
Right. Thank you. So without going into too much details, it can be quite technical. The US CBP says this, right? You must clear yourself and your operations and the visible supply chains of forced labor indicators, which includes, right, debt bondage issues vis-a-vis recruitment fees issues. When handling recruitment fees issues, always look at ILO's definition of recruitment fees, yeah, and under that they will say what the migrant worker has to pay, what the employer has to pay, and mainly it comes down to the employer pays principle, where IOM also has the IRIS standard. Yeah, work with third parties, etc., and you must remediate, yes, those workers who paid those fees under those circumstances. As for illegal or illicit fees, yeah, this has been a huge discussion, but generally migrant workers shouldn't have to bear that. You have to conduct due diligence in your supply chains and make sure these illegal payments are not paid or are not present in your supply chains. And if so, you must handle it. Engage with authorities in countries of origin or yourself, or don't engage with those recruiters who are found to take illegal or illicit fees. There's no specific statement by the US CBP on whether this is required to be paid, but they will generally rely on this ILO and IOM and other international standards, and will look at the independent third-party audits and see how you remediate these workers on recruitment fees. But it's also, of course, contextual and case by case as well. Next, please.
Thanks, Carl. Carl, I see someone has her hand up. Kai Xiang. Kai Xiang, do you want to go ahead?
Hey, thanks. Thanks for allowing me to respond. I think we can agree that workers should not pay these illicit fees, but also I think we should also appreciate the nuances that the fees have already been paid. Yeah, paid perhaps some years ago before it came to light. Right. So I think we are talking at different ends here. What should we do and what can we do legally? And I mean, you went back to mention about ILO's definition of recruitment fees. I think we have to set the scene here. Is illicit payment not to recruiters, but to middlemen, dalals in the village level? Are these considered recruitment fees? Right. I think if we can have your opinion on that, that would be very much appreciated. Thanks.
Thanks, Kaishan. No, I understand that, and it is also unfortunate that we have not, kind of popularized due diligence, which should include all third parties, include outside of recruitment, outside of the recruiters, etc. So you got to map out the visibility, right, to be able to identify all these issues. And generally, of course, yeah, back to the ILO definition, generally illicit fees shouldn't be paid by workers, but whether they can now be remediated by companies, etc. That's one thing the NAP for forced labor is now looking at. Yeah. So under the NAP for forced labor in Malaysia, we are now coming up with a definition on recruitment fees and who should be paying what with specificities. Yeah. Such specificities which will engage all stakeholders to discuss on who has to pay what, etc. But ultimately, I don't have the US CBP's answer for this. International standards merely say that the workers shouldn't pay for it. How we should then handle it is as I said. But I do understand the problems and nuances around this issue, and it can get quite technical, really. And if you look at, for example, some of the repayment guidelines, like I believe Impact's one, you will see some views on this as well. Joanne, would you like to add anything on the technicalities of this recruitment fee?
Yes, I'm going to be quite blunt. It doesn't matter what you call the fees. The fact is that the migrant workers have paid it and they should be remediated. I get your point that some of these are illicit fees and we know that they're under-table fees, but that doesn't take away from the fact that the migrant workers have paid these fees and that they are still in that bondage.
Sorry, but can I interject for a bit here? I mean, they are not required to pay these illicit fees to middlemen to obtain the job. I think let's set that clear, right? I mean,
how do you know that?
Well, see, the thing is, who represented to them that they are required to pay this amount of taka to be recruited. Were they represented by the recruiter? Right. So
I can only speak from our experience in the assessments that we have conducted. And in the assessments that we have conducted, the workers were told that unless they paid, they were not going to get the job. So if you're asking me whether someone told them that they had to pay in order to get the job, then the answer is yes.
So from IOM's perspective, that is a recruitment fee then, because it is integral to the recruitment process.
Yes,
however,
correct.
How the legality question aside.
As long as the fees, as long as it's cost that's borne by the workers, then it's cost that's borne by the workers, right? You're right in saying that the ILO's definition would not rightfully include illicit fees, but these are still costs that have been borne by the workers.
Okay, so still nonetheless, companies who want to recruit from Bangladesh, for example, they would have to assume this risks and liabilities and then reimburse if they want to do business in certain markets. So, this is just in Malaysia, right? Migrant workers from Bangladesh don't just go to Malaysia. So how is Malaysian companies, both in the glove sector and the palm sector, gonna try to solve this issue? How is NAPFL gonna solve this issue when the problem is at host country?
I think that's why, as Carl said, the question of due diligence, and especially mandatory due diligence, is becoming more and more relevant these days, because we understand that yes, a lot of the collection of these fees happens in the countries of origin, which is why again we emphasize the importance that the companies here conduct due diligence on their recruiters there as well. And I think earlier Carl mentioned how important it is to have proper clauses in the engagement contracts with your recruiters that include that all these fees should be specified clearly, who should pay for it, and you should have clauses of consequences in your contract as well. So for example, if they breach this contract, then perhaps there would be consequences. Maybe the contract.
Yeah, no, for sure. So we suspend. For example, something happens. I'm sorry to take everyone's time, but if something happens, we suspend the recruiter in Bangladesh, but the Bangladeshi, poor guy, he still took on the 20K debt. So
it doesn't solve the problem at all. It doesn't solve the problem. That money is under table corruption money. We are aware. Yeah, if the company here pays it back, fine. One group of worker is now in a better position, but future workers will continue to pay because it's normalized in the country and in Asia. Workers, when we have interviewed them, are very shocked when you ask them, is it possible for me to get a job without paying all these under table? They can't believe it. So it doesn't solve the root cause.
No, you are absolutely right. There is no quick fix to this, which is why, the only thing that we can really do right now is to work with all stakeholders. It's important for us not to also abandon the recruiters, but also to work with them, to create awareness, to also guide them through the process, share your policies, also to educate them as well as to what should and should not be done. It's difficult, of course, because like you rightly said, it has been normalized. But the fact of the matter is we all recognize it's an issue. It's an issue that has to be solved. We know it can't be solved tomorrow. It can't be solved within the next month. But we have to start somewhere. I see that that Sue's on the line and Chan is on the line as well. But Alia, I also see that it's 12 o'clock. Should I pass this back to you?
If the participants, Ms. Su and Mr. Chan, I think if your questions can be provided concisely and succinctly, then I think it would be okay to take their questions, at least one or two of them. Yeah.
Okay, thank you, Alia and Joanne. I think I just want to add to the points that we are discussing with regards to illegal fees that is being paid by the workers in the course of recruitment. I think we first have to appreciate the fact that everybody along the employment supply chain will collect a certain amount of fee. That has been a common practice. from the country of origin. Therefore, in my mind, the rightful way to move forward on recruitment issues is to do a G2G arrangement, i.e. be it G2G arrangement, or we facilitate a collaboration between the various parties in the country of origin as well as the country of destination. That will be point number one. And then with regards to the due diligence, I think I have read many reports talking about carrying out workers' interview at 2 interventions upon arrival to ascertain whether they have paid any whatsoever type of fees, and including the receipts that they may have collected. And then the subsequent interview, a similar way of carrying out the questionnaire should be carried out 3 months later. And the rationale for doing that is because you want to allow your worker to adjust to the new working environment, culture, whatnot, and they are more relaxed and they will share more information. So that would be my 2 points of addition to this discussion. Thank you.
I have one question, very simple question to address to, I'm not sure whether Ms. Joanne or Mr. Carl Nazarin. My question is, there was one point that both of you have mentioned in your presentation that you recognize that the root cause is actually at the recruitment agents. May I know if IOM or for that matter UN or ILO has any initiatives to deal with the recruitment agents if they victimize the foreign workers, yeah, of their fellow countrymen through deception or whatsoever, and make them pay unnecessary fees? Is there any mechanism at the source country organized by IOM or ILO or UN for that matter to deal with such unscrupulous people? Thank you.
Thanks, Susan. Perhaps I'll take this briefly. Generally, yes, we have a program called the IRIS program, where IOM works with labor recruiters to get them certified to the IRIS international standard. Yeah. So this IRIS international standard is basically a certification where IOM is a scheme owner, but there will be third-party independent auditors who says that they conduct ethical recruitment in countries of origin. And also we provide capacity building throughout various levels and stages to get them to that IRIS standard for certification. Of course, other than that, we are engaged with governments regularly on policy work and on the ground work and CSOs, including with other UN agencies like the ILO, to handle, for example, clarifying definition of recruitment fees, encouraging and helping out with enforcement of recruitment fee issues in countries of origins, and various other projects around the matter. I hope that clarifies for now, Sijam. Thanks.
All right, thank you. Thank you.
Okay, I think it's already almost 12:05, so I think we should end this session here, because if we take everybody's questions, we could go on forever.
Perhaps, Alia, everyone is welcome to email me. And Joanne, I think you'll be sharing the slides as well with our contact details. So please, any questions, we welcome it very much. Thank you.
Okay, so Mr. Carl has said it. So if you have any more questions, please email him. We will send along the slides later in the day. So please do give us some time. Thank you everyone for joining us today. Thank you also to Ms. Joanne and Mr. Carl for your comprehensive presentations, and I hope you all enjoyed your session today. Just before you all leave, we would like to invite you all to tomorrow's training session conducted by the ILO. Just a quick one. Savita, could you help me? Sorry, give me a second. Yeah, so just to put the posters on screen, just for you all to know what the session tomorrow will be about. I'll also send the link to the registration form in the chat, so feel free to sign up. We would love to see all of you here again tomorrow. To the speakers, if you also are interested in the session tomorrow, feel free to sign up as well. But yeah, other than that, thank you so much to the speakers again and to all of you who participated today. Yeah, without further ado, without taking any more of your time, we will adjourn the call now. Thank you, everyone.
Yeah, thank you guys. Yeah. See you all tomorrow.